case briefs, and so much more. LSData's got what you're looking for.
In the 1995 Supreme Court case, Babbitt v. Sweet Home Chapter of Communities, landowners and companies sued the Secretary of the Interior for defining harm to include habitat modification under the Endangered Species Act of 1973. They claimed this decision caused them economic harm. The central issue in the case revolved around whether or not the Secretary's interpretation of the law was reasonable and within their jurisdiction. The Supreme Court scrutinized the language of the Act and its legislative history to determine if the Secretary had exceeded their authority in creating the rule. The Act prohibits the harming of endangered or threatened species, including their habitats. Section 9 of the Act declared it illegal for people to take endangered or threatened species without a permit. The Secretary defined harm as significant habitat modification or degradation that results in the injury or death of wildlife. The court also considered the economic impact of the rule on affected landowners. The lower court had ruled in favor of the Secretary's interpretation of harm, but the Court of Appeals disagreed and overturned that decision. The Supreme Court ultimately determined that the Secretary's interpretation of the term harm was consistent with both the language and purpose of the Endangered Species Act, as well as their broad authority under the law. In balancing the interests of landowners and companies with those of species protection, the court found the Secretary's definition of harm to be reasonable. As a result, the Supreme Court reversed the judgment of the Court of Appeals, upholding the Secretary's broader interpretation of harm in the Act.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class